And just one moment, everybody, because it's Monday, the computers are working slow. All right, everyone, welcome to the 187 District Court. It's Monday. Some people are still stuck in traffic, I know, on 35, but it's still going to be a great day. So let's keep it as a great day. It's a fresh start. These are the rules of the 187 District Court. You're in a courtroom, so you must behave as though you're in a courtroom. So anything that you could not do if you were physically in the courtroom, you cannot do on this Zoom screen. That means you're not allowed to smoke cigarettes. You're not allowed to be in bed cooking food. If you're at work, you need to find a place or remain stationary. If you violate any of the rules or behave unprofessionally, you'll be required to appear in court. That will make you have a horrible Monday because, as I said, traffic is bad. So you'll either have to catch the VIA bus or either get an Uber or a Lyft or either drive downtown, which means you're going to have to pay for parking. So everyone, let's behave as though we're in court. To all of the inmates, you're not allowed to use the chat box. If you use the chat box, you'll be sent back to your cell. To everyone on this Zoom, this is not the Bachelor. This is not the Bachelorette. You're not allowed to use this Zoom in order to pick up dates. You need to do that on your own time. I'm going to open the breakout rooms. When I open breakout rooms, it will invite everyone to a breakout room. Do not go to a breakout room unless I specifically call you by name and assign you to a breakout room. To all attorneys, if you have a plea bargain agreement with the state, no matter how small that agreement is, you need to put it in the chat box to Norma Ferguson. She's the court coordinator. She's listed as Ferguson coordinator. If your client is on bond, she will need to know your client's email address. Please do not text her, email her, chat with her, and ask if you can be excused. I'm the only one that can do that. To everyone who's a defendant or accused, your name will not be called. Your attorney's name will be called. I repeat, your name will not be called. Your attorney's name will be called. If you do not hear your attorney's name, one or two things have happened. Either they're Zooming in another court or have to be physically in another court, or either they're stuck on 35. Trust me, you will have a chance to meet with your attorney. When I invite your attorney to go to a breakout room, your attorney is going to probably want to speak with the state first before they ask for you in the breakout room. Attorneys, those breakout rooms are like going to the doctor's office. When you go to the doctor's office and they call you to the back, they're checking your weight and their blood pressure. You're not seeing the doctor right away. So everyone, put some patience in your pocket and let's have a great Monday. This is the order in which attorneys will appear: Charles Bont, Daphne Previty, Joel Perez, Javier Padilla, Brent Coffey, and Jorge Canales. Is there any defense attorney whose name I've missed? All right, attorneys, when I call your name, I need to know the name of your client. I need to know whether or not it's criminal trial division or family violence. Charles Bont.
I'm the pro tem prosecutor on a case with OL.
Good morning, Your Honor.
Good morning.
Judge, we have the competency hearing scheduled for the Thursday, the 19th. But maybe,
name?
I'm sorry?
What's your client's name?
Juan Reyes. But he advised me this morning he's tested positive, Your Honor, yesterday.
All right, and so when is the competency eval?
Thursday, the 19th, Your Honor.
And that's just for the doctor to see him and speak with him, correct?
No, we actually have the disposition. I'm not too sure what the results are, but I'll find out on Thursday.
All right,
Norma. And we have the issue that he tested positive yesterday.
Okay. Norma, can you see where that competency report is, please?
Yes, ma'am.
And see if you can get a copy to Mr. Perez. That way we'll know what the results are.
Yes, ma'am.
And then we will set this. As soon as I know what the competency disposition is, which we should know that in a few minutes, then I can figure out what date to set you for. So if you'll just be patient for one moment.
Sure.
I thought it was.
All right, Daphne Previty.
Yes, Judge. My client's name is Clayton Mullins. He's an MTR on a misdemeanor DWI that's in your court. I spoke last time to Marcus Sanders, and we were waiting to find out if the information that was alleged in the MTR, if there was discovery. And so you reset
right.
us to today to find out if we were able to get the discovery.
All right, I'll see you to breakout room number 2. Marcus will meet you there.
Thank you.
You're welcome. Javier Padilla.
Good morning, Your Honor.
Good morning.
I have, Mary Isabella Hernandez,
Criminal Child Division or Family Violence?
family violence.
I'll
It's a
see you to
sen-
breakout room number 3.
It's a sentencing, Your Honor, and she is in the courtroom. But
All
I
right.
have not received the pre-sentence report.
All right, if you put your,
I sent it this morning, Judge.
all right, it should be in your email.
It was sent this morning.
Okay.
And do you need to speak with your client?
After I look at the pre-sentence report, I would like to talk to him.
All right, let me know when you're ready for that. Brent Coffee.
You came home.
Look.
Was that?
Good morning, Judge.
Good morning. Who do you have?
June Barrera. She is an inmate unless she bonded out. In that case, I'm not sure where she would be.
All right, let me see. You say Barrera?
Yes.
Okay.
She's in the recall, Judge.
All right, thank you. No, I don't think she's in jail. I could be incorrect about that.
Right here.
She's in custody.
She's in custody.
I believe
All
she
right, I'm
picked up a
missing-
new number 1.
All right, I'm going to send you to breakout room number 3.
Thank you.
You're welcome. All right, Meredith, I'm going to send you to breakout room number 3. I believe you and Mr. Coffee have June Barrera. Is that correct?
Yes, thank you so much.
You're welcome. Jorge Canales.
Yes, Judge, I'm here on Eric Garay. I have a motion to reconsider sentence, and Angelina Macias.
All right, we'll take up Mr. Garay first. And I'm going to send you to breakout room number 4. And if you could go to number 4, and if someone from the district attorney's office could meet me in 4 with Mr. Canales, and everyone, I will be right back. And Paul, when I come back, we'll find out what is happening with your with the evaluation.
Judge, I'm still on hold with Meg. They're trying to look for the report.
All right.
Okay, thanks for bringing that.
Hello? Yes, what's up? Uh-huh. I'm reviewing it right now. Yeah.
Sorry, David, did you need to talk to me still?
No, I was just gonna say on Mary Hernandez, I got the tap, but I don't see the PSI.
Okay, I'll add it on there. Maybe I went too fast.
Judge, I'll be forwarding the report in just a few minutes.
All right, thank you.
So the robbery, I
So,
should
Monica says she does not want you to be.
they robbed is,
Okay, Judge, it's been emailed to all parties.
Thank you. All right, Joel, did you receive it? Joel Perez?
I haven't received it from the court. I received it from Carruthers Court, but it says it's password protected and I don't have the password, Judge.
No, Ms. Ferguson just sent that to you.
I
Okay.
emailed it to you.
Okay. I'm waiting for it to come through.
All right, but it's stating that he's competent. So Norma, his client has the medical issue.
Yes, ma'am.
So when can we recall this?
I can do it on the 17th of September, Judge.
All right, have you received all the discovery in this case, Mr. Perez?
I have, Your Honor.
All right, so because you were waiting for the competency, his plea deadline is going to be September 17th, and the court will not further extend any plea deadline dates.
Judge, will that be on Zoom? Because I'm going to be out of town that week, but I can Zoom in on that day if.
Oh, no, the 187 will continue to Zoom.
Okay, that's fine. Then I'll be available by Zoom on that day.
All right, thank you. Mr. Perez, unless you have someone else with us?
No, Your Honor, just that. So September 17th at 9 a.m., the plea deadline.
Yes.
Okay, Judge, that's all I needed.
All right, thank you.
Thank you, Judge. Talk to you later, Charles.
All right, have a good one.
You too. Bye.
Brent Coffey, you and Meredith Chacon are back.
We are back. We would like to talk to a CTD prosecutor about our cases.
All right, if you go to breakout room number 3, a prosecutor will meet you there.
Thank you
If
so
there's
much.
criminal trial division prosecutor available on June Barrera, please. Thank you. And Daphne Previty, you're back.
Yes, Judge, I am. We've conferred and we still don't have the discovery for the out-of-county arrests. I understand that the law enforcement hasn't turned it in yet to the Guadalupe County District Attorney's Office. So we'd like to request another reset to get that discovery of the things that are alleged in the MTR, please.
So state, what is the plan if you never receive this information? Because it seems as though maybe it won't be received. Because I mean, it's in the motion, it's alleged to have been committed in June.
Mhm.
I mean,
Yeah,
I'm sure somebody should have a police report somewhere, right?
It's a small county. I called again this morning just to check again, and they said they still don't have it. I don't know how things work in the other counties. I do think it's a long time for us not to have it yet, or for them not to have it yet. I guess our decision, we'll have to make a decision then. If you could reset it, Judge, and if it has to be for a contested, that's fine. And we can make a decision at that point.
All right, Normie, can you set Mr. Clayton Mullins for a contested motion to vote, please?
Yes, ma'am.
And where is Mr. Mullins?
He was on earlier. He had a vest on. Oh, there he is at the top of my screen, Judge.
Okay,
I'm here.
thank you. Oh, what date, Norma?
Give me 1 second, Judge. I'm looking at the calendar. 1 second.
And then Judge, we just like to have some time once that discovery comes in to make sure that we're prepared for whatever date it is as well. So
I mean,
we'll need to review it.
This is gonna be the date. Whatever date Norma gives me, that's the contested MTR date.
I'm going to pull up my calendar on another screen.
I can do September 1st.
All right, September 1st.
And Judge, will that be at 9 o'clock?
No, that will be at 2.
At 2. Thank you. I am available that day.
All right, thank you. See y'all September 1st at 2. And your client will need to be in the courtroom if this is going to be a contested hearing.
Yes, ma'am.
All right, thank you.
Thank you. Bye-bye.
Bye-bye. Mr. Mullins, you're excused. And when you come to the courtroom on September 1st, you'll need to have a mask.
Yes, ma'am. Thank you, Judge.
You're welcome. Have a great rest of your day.
You too.
Who is that in the courtroom?
Excuse me, Your Honor, Charles Mays for Mr. Dominique Devine. I believe he's in jail.
All right, and he has a violation report, but I'll send you to the breakout room to speak with a prosecutor.
Thank you, Your Honor.
You're welcome. Courtroom, if you could go to breakout room number 5, and is there a prosecutor available to speak with Mr. May on Dominique Devine? He has a possession less than a gram case and a theft case.
I am, Judge.
All right, thank you. I'm sending you number 5.
Thank you.
All right, Mr. Padilla, you're
Yes,
just
ma'am.
waiting on Mr. Garay, is that correct?
No, on Mary Hernandez.
On Mary Hernandez, we're going to start that at 10:30.
Okay. She's in the courtroom, but you just want me to log back at 10:30?
Yes, but you're taking care of your client, Mr. Garay, correct?
I'm sorry, what?
Do you have Garay as well?
No, I don't.
Ah, I'm so sorry. That's Jorge Canales. I'm sorry.
Okay.
All of the clients are coming together. And just 1 second. 1 second, please. All right, I'm sorry about that, Javier. Yes, we can take care of Mary Hernandez now if there is a prosecutor available.
Thank you.
No correction. Everyone, this is why court reporters are so important. We can't take care of it right now because our court reporter is stuck on 35. So she should be here shortly. She texted me and said she's dealing with 35 traffic, which now is the time to discuss, maybe there needs to be some great public transportation. It will, I always tell everyone, it would be great if you could get on a train from here and go directly to Austin, Houston, Dallas. Why can't that be done?
Well, I don't know why, Judge. There was a story in the newspaper yesterday about that, and it takes 2 hours. It takes an hour and a half to drive to Austin. It takes you 4 hours on the train to get to Austin. So I don't know why, but that's why people don't take it.
Well, I don't understand. Well, see, you need like a speed rail. I don't understand why it would take so long. Like other countries, you can get on it and bam, you're there.
I know.
Like even in DC,
Judge,
1 minute you're in DC, next minute you're in Virginia or Maryland. Yes, Tom.
can you put June Barrera in number 3, please? Her lawyers are in there.
Okay, June, I'm going to send you to number 3. So yes,
Thank you.
so that's where we are, Javier.
I'll just should I just log off and come back, or just hang on?
Let me see what her ETA is.
It's 20 to. Why don't I just check back at like 10:15? Would that be all right?
Yes, that will be fine.
Okay. I'll just log out and check back at 10:15. Hopefully she's there by then.
All right, thank you.
Thank you, Jay.
I can do this, and then I'll wear my gray jacket.
Tom is telling us what he'll be wearing. Hello.
Judge, we conferred with our client and we have a deal. I don't see Tom on here to text him or message him that we're ready for paperwork.
Oh, there he is. You call his name once instead of 3 times and he appears.
We would like to accept your kind offer if you can email me the paperwork.
Yes, let me just look at my email real quick and see if I have your email. Oh, what's that?
And I'm sorry, I didn't ask the judge. Is that okay if we do that today or do we schedule
Oh,
that a different
no,
day?
I'm always ready for us to do things today.
Okay.
Don't put
I got
off
it.
for tomorrow what you can do today, but I will tell you this, the court report is stuck on 35.
Okay.
Her ETA is 10 a.m.
Okay. That's perfect. That gives us plenty of time to review paperwork. Look at that.
Doesn't
You're
this
just-
make Monday even better?
Yeah.
It's like, can it get any better?
First day of school too.
It is. You know what is, we need to start doing photos where we do the first day of work, but since we work every day, what would be our first day? You know?
Well, you know, some
Is there-
some people work.
Is there a clerk on here?
I'm sorry, what?
A clerk?
Yes.
I need to get a waiver number from them.
All right, Robert.
What, you want to send me the info, Tom? Or
Yeah, I'll send you the nightmare.
Okay, cool.
Tom, I messaged you my email in case you didn't have it.
I got it. Thank you.
Be glad you're not in CPS court anymore, Judge Boyd.
Oh, what is happening?
Oh, it's just the system it's not CPS court. It's just the placement crisis is bad.
Oh my gosh. You know, I keep saying that there needs to be a CPS liaison worker in all courts,
Mm-hmm.
but you know, money.
Or at least one that's maybe on each floor, you know?
Yes, but you know, it should be easier to do now since it's Zoom.
Mm-hmm.
Because we have so many cases where we're trying to find placements for people.
Mm-hmm.
Meredith McIntyre doing a great job finding placement. I'm like, please let her be out of jail by now.
Oh yeah.
But we're going to check on that and make sure. And I'm in the middle of watching this series on Netflix. That's 5 seasons and it's subtitles.
Okay.
So that means there are 70 episodes per season. And it always ends on the cliffhanger, which means yada, yada, yada. In the words of Seinfeld, yeah, it's 2 a.m., you know?
Oh yeah. Oh yeah.
But I'm going to put it in the chat box to you. So if you're looking for something to watch, it is awesome.
I will. Oh, okay.
I don't know why people, would you please move Devine Dominique to courtroom breakout? All right, where is Devine? I don't think they're on this screen. Thank you. But But it seems like here in America, there are no more new series, really. Everybody's doing reality television. And my mom and my grandmother would always say, I don't need reality TV. You might as well put my life on TV. It's like I'm watching people live their life. Okay, scripted, but
Yeah.
pretending to live their life.
I think mine would be pretty boring.
Hey, you don't know until you actually see it.
No. I like all the home improvement reality shows. I know they're scripted. I know they're fake, but I like watching them.
I do like House Hunters International.
Oh, yeah.
I like like you said, the home improvement, because you get ideas.
Mm-hmm.
But I will tell you what I did learn when you watch those home improvement shows and they're walking around and they're redoing the kitchen and they're like, oh, all right, 5,000, change out the cabinets, new appliances.
No. In real
That's
life,
not
it's
what it
like
costs.
5 times the cost of that.
Yeah.
Either they'll go to the bathroom. They say, are you going to move the plumbing? No, we don't have to move the plumbing. Okay, 8,000.
Yeah.
And that's like gutting it, like taking it down to studs.
I like when they go to House Hunters and they say she's a freelance photographer and he works part-time at a whatever store and their budget is $1.2 million.
Oh, yeah.
And you're like, what are these people thinking?
But the ones I do like when people go to foreign countries
Mm-hmm.
and they say they want an apartment and then the person's like, okay, what do you want? I'm from Texas. They're like, okay, things are smaller. What do you want? I need at least 2 bedrooms, 2 bathrooms, a modern kitchen, but I want it to feel like I'm here in Spain. And they're like, and I want it in the city center.
Yeah.
And then they're like, what's your budget? $500 US. They're like, this can't be done.
No. And then they always complain. We used to live in Germany and they always complain. They're like, there's no closets. Well, they don't do closets. They have wardrobes. So what?
Yes.
So they'll look at the apartment. Oh, we just can't do this. There's no closet space.
There's no
Welcome to
closet.
Europe.
Yes.
Deal with it. Yeah.
It just amazes me. But then I always, of course, love the Paris ones because that's my happy place. There was only one couple who was in Paris. They tell the lady, they say, we want a view of the Eiffel Tower. I want a modern kitchen. I want this. I want that. And Adrian Leeds was like, what's your budget? And they were like, we don't want to go over 2.5 million. She's like, thank you very much. This can be done.
Oh, wow. We liked Paris.
Yes, I love Paris. There was one guy one time on there, he went to Paris and he said he worked for the government and his job was just to study Paris culture. And he had a budget of $5,000 per month working for the government, just studying Paris culture.
So he's a spook, like a CIA.
And his wife was like, well, this is great. I'm just going to work on becoming a chef. I don't know if he's still there or not, but if he was a spook, did they really want him on HGTV House Hunting?
Maybe that's his deep cover, he's like deep cover CIA. I don't know. I watch too many like spy movies.
Oh, yeah.
But yeah. I'm watching Tom's face. Like, when is my paperwork? I'm looking. Haven't seen the
Well,
email.
we're still waiting on Brenna. I hope there's no accident on the freeway.
I don't know. Doug and Carl were giving me a hard time because I decided to work from home today. They were like, oh, okay, just don't come in.
Yes, Mr. May.
Oh, Judge, I need you to visit with Meredith real fast. I think we almost got it for a plea. I just need to clarify a couple of things with Meredith, Judge.
Oh, you need to clarify things. Oh, okay. I'm going to send you to breakout room number 6.
Okay, thank you, Judge.
And courtroom, if you could go to number 6, please. And Norma, do you know, is Roger Perez running late?
I'm sorry, Judge.
Roger Perez, is he running late?
Let me check, Judge.
All right, thank you.
Judge, I just saw an email from Richard Birch in Judge Moore's court that apparently I have a setting over there. May I jump over there real quick? I'll watch for the email and I will come back to do the paperwork.
Yes,
Thank you.
you're welcome. All right, everyone, just give me one moment, please. Everyone, just give us a moment. The court reporter will be here shortly. All right, everyone, I have a court reporter update. 15 more minutes. So that's where we are. But remember, it's a great day. It's a beautiful Monday. It's not too hot outside. One second. Adrian Perez. You have Eli Cantu. I'm going to send you to a breakout.
Sorry, I kept you.
Oh, no. There's some sort of accident on 35, so the court report is not here yet. So no problem.
Okay.
All right.
I'm sorry to hear about that. I have a few other courts to run to. Do you mind if I attend to those and check back with you, Your Honor?
Well, if you could confer with the state because your client is on screen. And then once
Okay.
that's done, then we can, you can go to another courtroom. So I'm
Okay.
going to send you to breakout room number 2.
Okay. Thank you.
You're welcome. And if I could see Marcus Sanders in breakout room number 1, please. All right, everyone, we are so close. So if anyone needs to quickly go to another courtroom, you're more than welcome to do so. And as soon as the court reporter arrives, we'll take up your matters.
That's basically what you're saying. Okay, beautiful. Beautiful. That's what I want. Let's go with that.
Excuse me. Are y'all done with Devine?
No, just one moment.
Yes, ma'am.
No, we're not done with Devine.
Okay, let me get him back.
Thank you.
Yes, ma'am. And one more question. May I use the restroom?
Devine, you're not done.
Yes, ma'am. Thank you.
You're not done. Devine's not done.
Boss man. Sir.
Mr. Devine, you're not excused until I excuse you, okay?
Oh, I'm sorry, my fault.
That's okay. Roger Perez,
Judge, I'm here regarding,
Blinko.
Judge, I'm here regarding a Thomas Blinko that did some pretrial violations. I have not been able to get a hold of Mr. Blinko.
Okay. Well, we will find out what's going on. Do you still wish to confer with the state?
Not at this point. I think it's just regarding some pretrial violations, if I understand it.
Yes, but he does have an open case here, so you may want to confer with the state in case Mr. Blinko does make an appearance.
That would be a very good idea. I'm going to come back for that because I'm going to take a plea in another courtroom and I'll come back for that.
All right, thank you.
Thank you for your prompt attention, Your Honor.
No problem. Right. Ms. Chacon, do you need to be in a breakout room with your client?
Yes, Your Honor, I'll need to go over the paperwork. And I apologize, I was gone so long, but I worked out another deal. So I'm going to do this and then go back and hey.
Oh, no. The court reporter hasn't arrived yet.
Okay.
My understanding there's 2 or 3 accidents on 35.
Oh, no. Okay. Well, yes, I'll go do the paperwork with him. And if she's not back, I can go finish my plea in the 187th and then come back again.
All right. So I'm sending you to number 4 and your client is June, correct?
Yes. Thank you.
You're welcome. And Jorge Canales, did you need to go over the motion to revoke with your client, Mr. Garay?
Judge, I spoke to him about it. I believe he knows what is going on now.
All right, I'm trying to find your client. I don't see them on the screen at all. Just one moment. Or Norma, could you make sure that Mr. Garay comes back, please? He's in custody. And I
Yes,
don't
ma'am.
see him on the Zoom screen.
Yes, ma'am. Judge, they're bringing him back.
Okay.
He said he was done, Judge, and he took off. Inmates do not leave.
All right, Christine McDonald, who do you have?
Yes, Judge. I'm here on State of Texas versus Rodney Ferguson. If I can be put into a breakout room with my client, please.
All right, and is this criminal trial division?
It's family violence, Judge.
All right, Mr. Ferguson, I'm going to send you to breakout room number 3. Mr. Ferguson, it should pop up on your screen. Mr. Ferguson, unmute yourself. Okay.
Yes.
So, Mr. Ferguson, we're going to try our hand at independence. Do you see at the bottom of your screen, do you see where it says participants?
It says temporarily unmute.
No. Do you see the words at the bottom of your screen?
It says Judge Boyle is inviting you to join the break.
Yes, so click on that.
I don't have the clicker. These officers got to click.
They took the clicker away from you. They only have one mouse.
Anytime you see that.
Mr. Ferguson, did you tell him I was inviting you to a breakout room?
Your Honor, inmate Devine will need to join the breakout room with the courtroom to go over the paperwork.
All right, Mr. Devine. Let me see. I'm going to send you to breakout room number 8.
Yes, ma'am.
Well, let me move you to 9, and the courtroom will meet you in 9. Do you see that on the screen?
It hasn't popped up yet, but no, ma'am.
Do you see it on your screen now?
About a breakout room, no, ma'am.
All right, do you see anything at the bottom of your screen that says participants, chat, and breakout rooms?
No, ma'am.
Okay, it's a Monday. It's official, everyone. But we'll still make it a nice Monday.
Yeah, well.
But the good thing, Javier, it can only get better. Oh, you're on mute, Javier.
Yeah, I said, it'll get better, Judge. It'll get
Oh,
better.
it will. You know, as far as I'm concerned, Monday has thrown a lot at us this morning, but everyone still has their patience. That's a good thing. So we're going to get her done.
What's going on at 35? Accidents or?
Yes, my understanding, Brenna just told me she's parking.
Parking, okay.
But my understanding from the deputy is there were like maybe 2 to 3 accidents on 35. I think it's because everybody's rushing. If
Well,
people just stop,
school and lots of traffic and everybody's in a hurry and all that.
yeah, if people would stop rushing, you know, I think it's most important to arrive at your destination safely. So, Devine, if you don't know how to go to a breakout room, you need to ask a deputy.
Yes, ma'am.
Thank you. But that's always been my motto. I think hopefully people in our life would prefer us to arrive safely than to rush to be on time, you know?
That's right. Luckily, I live very close to my office. I only have a 4-mile commute and I don't even have to get on the freeway to get here. So
Well, it seems like the closer you live to a place, the later you wake up. Then it becomes, oh, the appointment's at 9, but I'm 10 minutes away. I could probably get up at 8:50 and still make it.
I always wake up early. My dogs make sure I wake up early.
Yeah. I always have to apologize, although I didn't do it because I always knew the value of sleep, even when I was a child. But children will wake you up on a Saturday at like, Meredith, 5 a.m. or something? But then when you try to get them up on Monday, they can't, for some reason, Monday they can't get up.
Very true.
And so I have to apologize on behalf of my brothers to my mom because they would get up at the crack of dawn. Me, mom would always say, Stephanie, don't sleep your life away. I'm like, it's Saturday. I can stay in bed. Let me just stay in bed. She's like, no, don't sleep your life away. All right, so I'm signing the paperwork on Barrera, and then we will get that person sworn in, and Meredith will get your person sworn in, and then we'll be ready when Brenna comes through. To the clerks, I'm sending paperwork in on Barrera. If you could go to the breakout room and swear her in, please.
Okay, Judge, I'll go right now.
Thank you. And she is in breakout room. Sorry, June Barrera, could you go back to breakout room number 4 for me, please? Do you know how to do that? And the clerks will swear you in. If you don't see it, again, I can just move you. Let me just move you to number 1. All right, the person with the ceiling fan over there, that seems like something from paranormal. You know, where you just see shadows on the wall.
Judge, that's our victim's mother, I believe, for the impact statement.
Okay, and which case is this again?
The last name of the defendant is Macias.
Ah, okay. And Norma, on Garay, I need a consent to plea by video and a trial court certification.
Okay.
And the attorney on Garay is that Jorge Canales? Yes, let me see. Jorge, if you could go to a breakout room with Mr. Garay, I'm going to send you to breakout room number 4. Ms. Ferguson is going to send paperwork to you all.
Okay, Judge.
And Mr. Garay, if you go to 4, and Mr. Garay, you're not excused from this courtroom until I excuse you, okay?
Judge,
Yes.
when you have a minute, can I be put in a breakout room for Rodney Ferguson with the state? It's family violence.
All right, I'll send you to breakout room number 5.
Okay, thank you.
You're welcome. No. All right, everyone, the court reporter is here. She is just setting up her equipment.
There's just 2 documents missing, some information in the waiver of indictment. I already let Marcus know.
Okay.
Just when he comes in. I'll bring it to you.
All right, thank you. Robert, it should be coming to you now. All right, everyone needs to give Brenna, our court reporter, a round of applause, because if you didn't know the importance of a court reporter, I think we all know it now. I always do it, but you all need to give her a round of applause. Brenna, I'm glad you made it safely. My motto is always arrive safely. All right, so Brenna, just let me know when you're ready.
Look. That's cute. Okay, Judge, I'm ready.
All right, thanks. Now, and you all can ask Brenda, why didn't she just walk the 40 miles? I don't know. All right, so we're going to start with June Barrera, and then Javier will take up your case, and then Jorge will take up your case.
Judge, on June, I forgot that it was a indictment waiver, so I just sent that now. So Meredith
Okay.
should be.
Yes, and I just signed it, and I hear him loudly stamping, so it should be here. Brenna, everybody's so happy to see you. All right, and let me just check. Let me connect. It's a beautiful Monday, everyone. All right, Meredith. It says that a document is still sitting in your client's. It's the waiver.
Oh, okay.
So let me send you all back. And Miss Barrera, let me find you. All right, if you can go to breakout room number 4.
Will do.
All right, and Meredith, let me find you. Yes, if you all could go to 4, we'll take care of it.
All right.
Sure.
Yeah.
All right, Javier, who do you have?
Mary Isabella Hernandez.
All right,
She should be in the courtroom, Judge.
All right, and this is family violence. Is family violence ready? All right, and Deputy Laura, could I have Mary Isabella Hernandez come forward, please?
Yes, Judge.
Thank you. All right, the court is calling 2019 CR 6034, State of Texas versus Mary Isabella Hernandez. Can I have parties announced for the record, please, for the state,
David Martin.
for the defense?
Javier Padilla, Your Honor.
Right. And are you Mary Isabella Hernandez? I need you to speak.
Yes, ma'am.
All right, we're proceeding by video. The court will note for the record that the defendant is in the courtroom. Any objections to us proceeding by video, state?
No objection.
Defense? Ms. Hernandez, any objections to us proceeding by video?
No, ma'am.
All right, and the court will note for the record that the defendant entered her plea by video on June 24th. She entered a plea to count 1 of no contest. Count 2 and the enhancement paragraphs were waived. The court found there is sufficient evidence to find her guilty, but deferred finding of guilt. According to the plea bargain agreement, punishment was to be assessed at a cap of 8 years in the prison. The state would remain silent on the defendant's application for deferred adjudication or community supervision. And there was an affirmative finding of family violence and $100 to an approved family violence center. And outside the agreement was no contact with Monica Bustos. Have both parties had a chance to review the PSI report? State?
Yes.
Yes,
Defense?
Your Honor.
Any objections to the PSI report? State?
No objection.
Defense?
No, Your Honor.
All right, defense, the state is silent. You may proceed.
No, thank you. Before I call Ms. Hernandez, Your Honor, I'd like to say a few things. It's obvious that Ms. Hernandez has had a criminal history and does have a criminal history. But it's also important to note that this particular incident with this lady, Monica Bustos, resulted from a very brief relationship that they had. Since this happened, there's been no contact with her whatsoever. She can assure you that there will be no contact in the future. Ms. Hernandez is now working. She's been employed for a year. She lives with her parents. She takes care of her mother. She's 51 years old, and she'd like to put all this behind her and turn a new page in her life. And I think she can do that if the court puts her on community supervision. So with that, I'd like to ask Ms. Hernandez a few questions. Your Honor.
All right, could you raise your hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, I'm going to need you to make sure you speak up.
Yes, ma'am.
All right, you can lower your hand if you could state your name for the record, please.
Mary Isabella Hernandez.
Defense?
Okay, Ms. Hernandez, let me ask you a few questions. Where are you working right now, and how long have you been working there?
I work for Villas of Castle Hill, assistant maintenance. And I've been there for going on, A little bit less than a year.
Okay. And where are you living right now?
At my parents' house.
And are you hoping to take care of your parents?
Yes, sir. My mom is, she's got diabetes real bad, and she's got high blood pressure, cholesterol, and stuff like that. So, like, I do a lot of running of their errands and things like that.
And how old is your mother?
My mom is 66.
Okay. Now, Monica Bustos, since this happened, have you had any contact with her?
No, sir.
Do you intend to have any contact with her?
No, sir.
Can you assure Judge Boyd that you will never have any contact with her?
I can assure that.
Okay. This relationship that you had with her, how long was that relationship, if you can estimate the time?
I would say it was like 4 months, 6
4
months,
months?
maybe the most, yeah.
Okay. And can you assure the judge that if she puts you on probation, you will comply with whatever she directs you to do? Whatever instructions and orders she may give you, you will comply with?
I guarantee it, sir.
All right, thank you, ma'am. That's all, Your Honor.
All right, any questions from defense? I'm sorry, from the state?
Yeah, no objection. Or no question, sorry.
Okay, it's Monday, it's Monday. All right, I do have a few questions. Just one moment. All right, so certain questions I have of you. Just one moment. All right, I'm looking at your criminal history. Now, some of it, for example, the driving while license suspended. That's, of course, it's an offense, but it's not a violent offense. So what I want to focus on is the violent offenses and the fact that you've been on probation before, which tells me if you've been on probation before, that you know the rules of probation.
Yes, ma'am.
So we have a theft case. Now, the cases here that have been dismissed, the failure to identify, the assault, bodily injury, married, I'm not focusing on that. That's dismissed. I don't know why it was dismissed. So I'm not focusing on that or giving it any weight. But we have an assault, bodily married here. And you were granted deferred for that.
Yes, ma'am.
Then we have a driving while intoxicated. You were sentenced to jail. Again, another assault, family violence, 2018. I'm not going to focus on that because it was dismissed. Harassment, 2019, dismissed. Shoplifting, Palm Beach, Florida, unknown. I'm not focusing on that because it says unknown. I'm not going to ask you about that. Evading arrest with a vehicle, given deferred adjudication, it was revoked. Aggravated assault, seriously bodily injury, you were sentenced to prison for that. And then now we have an assault, family choking. And we have this continuous violence against family that was dismissed. I'm not even going to consider that. Harassment, dismissed. I'm not going to consider that. Attempt to commit aggravated assault with a deadly weapon out of Medina County. There's nothing here on that, so I'm not even going to consider that. But the court's concern is you have violent history, and now you're before me again with another violent case.
Yes, ma'am.
So why should I place you on probation when you have a violent history? And this was an assault choking.
That's it. Can I speak?
Yes. I mean, I'm asking you, why should I place you on probation?
That female that I was with at that time, I told her about the history, about what happened when I went to prison and stuff like that. And it was a situation where she knew my past. And when I came out with a different mentality where I wasn't gonna get into those type of situations again to get, I mean, it was a situation where like, she was doing drugs. She was doing stuff that I didn't know about, and this situation, she over exaggerated a lot of things that didn't really happen, because I don't know, she just took advantage of the situation, and this is why we're here now. But as far as giving me a chance to be on probation, I just want to, before my life, I don't want to be going back to the same stuff, and I just want an opportunity.
But see, here's the thing. Your record suggests that you've been given opportunities. That's where we are. And I've read the police report. I've read the PSI report. And according to the police report, this all took place at a bar. It doesn't matter if you were drunk, she was drunk, or nobody was drunk. In the stipulations, it says that people had to come to her aid to get you off of her. That's what it says. It says here, you followed her into it says Monica claims they were at a local bar owned by her family. She stated as the night went on, she was talking to other females at the bar. Monica stated this upset Mary. Monica stated she went to the restroom and Mary followed her inside. At this time, Monica states Mary pushed her against the wall, then began to choke her. Several staff members came into the bathroom to help her. Mary was removed from the bar as Monica stayed behind for fear Mary would hurt her. So that's what I have. And that's, I mean, those were the items that were stipulated to. The court reviewed them. The court found there was sufficient evidence to find you guilty. However, the court deferred finding of guilt because you applied for deferred adjudication. So again, we're still at the point where your criminal history is one of violence. And I have before me another case that's one of violence. So it's sort of, why shouldn't I send you to prison? And let me just explain something to you. I treat every case individually, right?
Yes, ma'am.
But sometimes, and I'm not saying this is with you, but sometimes people think that if women commit violent offenses, that they should be treated differently from if men commit a violent offense. But for me, a choking is a choking. And I found there was sufficient evidence to find you guilty of choking someone, which would be the complainant in this case. I know that the complainant said that she didn't want to go forward with this case, which is not unusual for anyone who's complaining in family violence cases to not want to go forward. So my question is, you have violent history. I have before me another violent case. You've gone to prison for a violent case. You've had misdemeanor cases that were violent cases. So why am I going to give you probation? Like, I don't understand. Why should I give you probation when you've had chances at probation? You've been to prison for a violent offense. You're out. And now I have before me another violent offense. And it's not as though you went to prison for a violent offense and you hadn't had experience with violence before, because you have misdemeanor cases that are family violence cases. You were given deferred adjudication. You completed it. So supposedly you were to have learned something about controlling your anger. But obviously that's not the case because we're back here again.
Answer, Mary, why should she give you probation? Answer that for her, please.
I feel that I should get probation because like I tried to explain earlier, the situation with this person, Monica, it was exaggerated. I mean, half of the stuff, when I came out, I knew that I was gonna do something different, and I have. And it's just, this person has exaggerated a lot of the situation, and it's not even how they said it happened. Her family, are friends of mine, were the place of the thing happened, the situation. And the owner, she says, she goes, that's my cousin. She goes, and I know that's how she is. She goes, and I mean, I haven't talked to her. I haven't been around her. I don't want anything to do with that situation again. I want to do probation if you grant it, because I have a lot of things going for me now where I never had before. And I'm trying to get ahead and put that behind me now.
All right. Is there anything else from defense?
No, Your Honor.
All right. The court's going to deny your application. The court will find you guilty. The court will not grant you community supervision. State you're silent on the application. Are you also silent on punishment as well?
Yes.
All right. Defense, anything you want to say with regards to punishment?
Well, Judge, it's a very difficult situation. I know that this and on this past history factors a lot into this, but I do think she deserves an opportunity to get her life back together. So I would recommend a short sentence. Once she gets out, she can get back with her life. I would recommend a sentence of 2 years to allow her to have some time to reflect on what's happened, but then allow her to continue with her life before too much more time passes. And she is 51 years old now, so I would hope we'll regret that opportunity.
All right, the court will note that the defendant has made improvements to her life and has not had any contact with the complainant in the case. And I'll note that in the PSI report, the complainant wants the defendant to have a chance to do better. So this is what the court will do. As previously stated, the court is finding the defendant guilty. There's an affirmative finding of family violence. There's to be no contact with Monica Bustos, B-U-S-T-O-S. 2 years in the prison, give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it? Sorry, did you review that?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, Mr. Hernandez, good luck to you. When you get out this time, you probably need to take some anger management courses and think about which relationships you want to be in. You understand?
Yes, ma'am.
All right, good luck to you, Mr. Hernandez.
Thank you, Your Honor. My excuse?
Yes, thank you for your patience. Have a good rest of your day.
Yes, ma'am. Thank you.
All right, Meredith, you're back?
I'm back. I just went and checked in with Judge Moore and said, I'm coming back. I'm coming back.
Okay.
Monday.
All right, we are ready for you.
Thank you.
And Marcus, could you show your video, please? Court is calling 2021 CR 7309W, State of Texas versus June Barrera. Can I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Meredith Chacon for Ms. Barrera, Your Honor.
All right, and are you June Barrera? I need you to unmute for me, please. If you'll hold down the, yes. Are you June Barrera?
Yes, ma'am.
We're proceeding by video. Any objections from the state?
No objection.
Any objections from the defense?
No, Your Honor.
Ms. Barrera, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you the acknowledgement of discovery. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Next, Ms. Barrera, I'm going to show you a document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement, you're waiving your right to have a grand jury hear the evidence in this case and make a determination on whether or not to hold you over for a trial and indict? Did you understand that?
Yes, ma'am.
Did you understand that you're also waiving certain rights that your attorney has, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, ma'am.
And did you intend to give up those rights in this
Yes,
case?
Yes,
Right,
ma'am.
thank you. Court will find the defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Next, I'm showing you what's entitled information. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, Your Honor, we do.
State, are you proceeding on the information as presented?
Yes, Judge.
All right, Ms. Barrera, I'm going to show you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what the state is charging you with is theft from person? The range, that's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Barrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, state is proceeding on the offense of theft from person. They're asking that your punishment be assessed at 100. Are you all proceeding under 1244?
Yes, Judge. I forgot to check that box.
All right, any objections to the court checking the box that the state is proceeding with Bexar County jail time under 12.44?
No objection, Your Honor. We did go over that.
Did you understand that the state is asking that you have a state jail felony conviction under 12.44 of the penal code and that you be sentenced to 180 days in the Bexar County jail? There are no applications. The state will take in consideration grand jury number 743954, 756160. There's to be no contact with Stephanie Villa or the Family Dollar located at 6110 West Commerce Street. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense of theft from a person, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's no contest plea.
Yes, State offers State's Exhibit 1 and its attachments.
Any objections?
No objections, Your Honor.
Ms. Barrera, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
That was my understanding.
Anything you wish to say on behalf of your client?
Your Honor, I just ask you to follow the plea bargain agreement. I believe that she has taken responsibility.
All right, the court will sentence you to 180 days in the Bexar County Jail under 12.44 of the Penal Code. Give you credit for any time served. Take in consideration grand jury numbers 743-954, 756-160. There's to be no contact with Stephanie Villa or Family Dollar at 6110 West Commerce Street. Is there anything else from either side with regards to sentencing?
No, ma'am.
No, Your Honor.
Ms. Barrera, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Also, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, with that, we'll close the record. Ms. Barrera, you need to make some decisions on what you're going to do when you're released. Do you understand?
Yes, ma'am, I do know.
There are plenty of places that are available to help you. I noticed that many of the items stolen were shampoo and things of that nature. So there are many free places in the county that can help you, all right?
Yes, ma'am.
All right, the other thing, that tattoo, was that tattoo painful? Meredith and Marcus know I always ask about tattoos.
What tattoo?
All right, the one that's on your chest, is that not a tattoo?
Oh, yeah. Yes.
Was that painful?
Somewhat of, no, not really at the time.
All right, are you planning on getting more tattoos?
No, it stopped.
Okay. All right, well, have a great rest of your day. Do better, okay?
Yes, ma'am. Thank you.
You're welcome. Norma, can you let them know June number 12 can go back?
Yes, ma'am.
All right, Meredith, if you don't have anyone else with us, then you're excused.
Thank you so much. It was nice to see you.
All right, thank you. You too. Have a good one.
You too. Bye-bye.
All right, Jorge Canales, and then I'll take up Mr. May. All right. Mr. May.
Yes, Your Honor.
Yes.
Yes, we're ready. All the paperwork should be signed and everything, Your Honor.
All right, let me see if I have that.
Mr. Dominique Devine.
All right, to the clerks, do you have paperwork on Dominique Devine?
Actually, Judge, can I go in a breakout room with the attorney really quick?
Yes. Mr. May, I'm going to send you to courtroom. If you could go to 8, please. All right, Adrian Perez on Mr. Cantu.
Yes, Judge, that's the sentencing. I've reviewed the PSI and the TAP. I'm ready to proceed whenever the court is.
Okay.
And Judge, it'll be me. Could I have 1 minute?
Yes. And Jorge Canales, if you
Yes,
could,
Judge.
did you receive all the paperwork on Garay?
I did. We signed, received the consent for video and the trial certification.
All right, if you could go back to number 3 and have your client come out of the breakout room, please.
I will, Judge.
Thank you. And to the clerks, if you have the paperwork on Garay, please. Thank you. And Robert on Garay, there should be a new motion. Yes, it should be a. Marcus, are you ready on Cantu now?
Yes, Judge. Thank you.
Okay. All right, Jorge, they're going to print out the motion to revoke for me, and then we'll take up Mr. Garay. And we're going to proceed then with Mr. Cantu first, and then we'll take up Mr. Garay next.
All right, Judge.
Thank you for your patience.
Yes, ma'am.
Oh, I don't know why it did that. Sometimes it goes crazy. I think it gets people's names wrong or something. All right, thank you so much. Oh, and this can go back. Oh, yes, please. Let me give this to you.
Judge, I sent you a chat.
All right, thank you. Brenda, it's funny. People send me chats, and when I do text messages, I spell everything out. That's why my text messages are long. So it took me a while to find out what BRB means. And I'm like, oh, be right back. All right, the court is calling 2021 CR 3424, State of Texas versus Eli Moody Cantu. Can I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Adrian Perez.
All right, we're proceeding by video. Any objection from the state?
Objection.
Any objections from the defense?
No, Your Honor.
All right, the court will note for the record that another judge took this plea on May 13, 2021. I know there was an application for deferred adjudication. And based upon the signatures that I see on the plea paperwork, this was done by video. According to the plea bargaining agreement, punishment is to be assessed at a cap of 10 years in the prison. The state opposes your application for deferred adjudication or community supervision. This is to run concurrent with County Court Cause number 639824 and 655575. State will take in consideration 2020 CR 12346, County Court Cause number 639825, and there's to be no contact with Hannah Garcia or Canrad, Kanrad Romero. Have both parties had a chance to review the PSI report?
The state has.
Yes, Your Honor.
Any objections to the PSI report from the state?
None.
Any objections from the defense?
None.
All right, state, you're opposed, you may proceed.
Yes, Judge, we're opposed to his application because of his criminal history mainly. I know this is a felon in possession, but based on his criminal history that we can see in the PSI report, he's been given opportunities at probation and he's failed to complete it. He has a history of violent offenses, specifically a deadly weapon where he spent a year in jail in '98, a Berg hab, which we don't know the details of, but it looks like he got probation on that and was revoked, as well as the arrests that were TIC'd as part of his plea in this case for aggravated assault. Initially, it looks like he has some federal cases that he's been sentenced on, bank fraud and aggravated identity theft. So we do not believe that he is a good candidate for probation, and we're asking that his application be denied.
All right, defense.
Your Honor, I'm asking that you put Mr. Cantu on deferred adjudication. Looking at the PSI, Judge, I'll speak first towards his criminal history. I would say, Judge, that the only violent offense that I see on his record was, well, there was one as a juvenile in 1991. I guess that would be 30 years ago. And then we have another ag assault deadly weapon that was in 1999, but it was rejected without an indictment. So, Judge, I would argue that he does not have a violent history. We also had one May 2020 that was TIC'd into this case. So I would argue, Judge, he does not have a violent history at all. Second, Judge, I would call to the court's attention that although he has a criminal history, we're looking at a DWI, a theft by check, another theft, stealing or receiving checks, possession of a criminal instrument, burglary of habitation, forgery, bank fraud, identity theft, another fraud. I think we're looking at crimes that suggest that there is an underlying problem, and that underlying problem 99 times out of 100 is a substance abuse problem. I think that's why Mr. Cantu has this history, is because he's had a bigger issue that he's not received help for, and he's ready to receive that help. And I think that if you give him the opportunity to do a rehab, I don't think he would let you down. Further, Judge, I don't think that you really have anything to lose. Looking back at his criminal history, it looks like he's done a little bit of time in custody here and there, but it doesn't look like he's done any substantial time. It looks like, frankly, it looks like as towards his state felony cases, he did a year in jail for a deadly weapon in 1998. Which again is over, I'm not a mathematician, but over 20 years ago. He had a burglary of a habitation, which looks like he completed his probation. It says unsatisfactory, but nonetheless, he did complete his probation. And then we have a bunch of other cases that were either rejected or TIC'd. Insofar as his federal cases, in 2013, he did 6 months prison. And then it actually looks like on another case, he did 24 months prison with a, so he did one stint in federal prison for 24 months, I'm guessing. So he's not really done any significant prison time. And I don't think that prison would really help him. Going down further on the PSI, Your Honor, it looks like Mr. Cantu does have some mitigating circumstances. He's been treated at a psychiatric hospital, Southwest General Hospital. He's been treated at an MHMR facility, Casa Real Mental Health. He presently has possible schizophrenia, depression, and anxiety. He's on Abilify and another medication, presumably for his mental health. Judge, he's attempted suicide in 2012. He only went to 6th grade. And frankly, Judge, I think that all of these factors, while they don't excuse his behavior, they should mitigate his punishment. He's had a hard life, and while he's still responsible for his actions, I think we should give him a chance to at least get on equal footing and be able to show to the court and to himself that he could be a productive member of society. Insofar as this case, Judge, this is a nonviolent case. He was getting pulled over. He had a warrant. He had a gun. And that's what we're here for. I'd like the court to consider that as well. The TAP evaluation looks like it recommends evaluation for a residential facility followed by Genesis. And I think, frankly, that he would benefit for that. I do think that he needs structure. I think he needs a drug rehabilitation. I think he also needs a rehabilitation that focuses on maintaining a productive straight edge life. I think that he needs that structure. And I think if he's given that structure, I think that he'll follow it. So Judge, I'm asking that you put him on deferred adjudication with whatever conditions you see fit. If you do send him to prison, I'd respectfully ask that you give him no more than 5 years.
All right. Mr. Cantu, I'm looking at your criminal history. Again, things that are dismissed, I don't take those in consideration at all. I realize this aggravated assault serious bodily injury was juvenile. Violation of probation, juvenile. And maybe when people are young, they don't take things seriously. That I understand, that happens sometimes. But then we have the adult record. So in 2004, driving while intoxicated, and I realize this is 2004, but the reason why I bring it up is because you're on probation. If you had a drug problem, they would have addressed it. Then in 2020, we have a theft case. Then evading arrest or detention. 2021, 3 months, 10 days in jail. Felony, 1998, deadly weapon conviction, guilty. Sentenced to fine and a term in the Bexar County Jail. I'm assuming it was the Bexar County Jail. Then we have a burglary of a habitation force from 2010. Again, this would have been time for you to get help with any type of drug issues you had. And now we're here with these state cases. Some of them are being taken in consideration, and I won't consider them since this aggravated assault with a deadly weapon is being taken in consideration. I'm not going to consider that in my sentencing of you. But then we have federal cases, bank fraud, supervised release. And I realize that on supervised release, they will, if you have drug problems or drug issues, you can receive help from that. Now, usually people will say, well, people are not taking drug issues seriously in the early 2000s, but this is from 2013. So surely at that time, they would have helped you if you had drug issues. And it's the same thing with this aggravated identity theft. They would have helped you. And what we have from my reading of the stipulations is you jump out of a vehicle, you take off running, the police tell you to stop, you don't stop, they tase you. Then you continue to run after the probes are released. So I'm going to deny your application. I'm going to find you guilty. I'm not going to grant you community supervision. State, did you want to speak to punishment?
Yes, Judge, we would ask for higher end of the range, I guess 8 to 10 years.
And defense, what are you requesting?
Judge, I was asking that you give him no more than 5, Your Honor.
All right. All right, I'm going to sentence you to 6 years in the prison, give you credit for any time served. This will run concurrent with County Court Cause number 639-824, 655-575, taking consideration 2020 CR 12346, County Court Cause number 639-825. There's to be no contact with Hannah Garcia or Conrad Romero. Got to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney and did you understand it, Mr. Cantu? You need to unmute yourself.
Right there.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? You're on mute.
Yes, ma'am.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, Mr. Cantu, good luck to you. If you need help with any type of drug treatment, of course, when you're released, they will take care of that for free. There are so many free locations. And if you would like, I can ask that you be placed for consideration with the therapeutic community. With the therapeutic community, it does not extend your prison sentence, but if you're accepted into the program, that is a treatment program. Would you like to be considered for the therapeutic community?
Yes, ma'am. Yes, ma'am.
All right, Mr. Cantu, good luck to you, okay?
Yes, ma'am. Thank you.
All right, you're welcome.
Thank you, Your Honor.
All right, Norma, can you let them know that L2 can go back?
Yes, ma'am.
Thank you, Your Honor. May I be excused?
Yes, thank you. Oh, who is taking up Garay?
I am Judge.
All right, the court is going to call 2021 CR 4792, State of Texas versus Eric Garay. Can I have parties announced for the record for the state?
Meredith McIntyre for the state.
For the defense?
Jorge Canales for defense.
And are you Mr. Garay?
He's
You need to
unmuted.
unmute yourself.
Yes, ma'am.
We're proceeding by video. Any objection from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Garay, I'm showing you a document entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it?
Yes,
And
ma'am.
did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Eric Garay who was placed on community supervision in cause number 2021 CR 4792 for the offense of assault?
Yes, ma'am.
I'm sorry, assault household member previous conviction
Yes, ma'am.
on August 3rd, 2021 for a term of 5 years. Is that you?
Yes, ma'am.
State?
On or about the 16th day of August, 2021 in Bexar County, Texas, the defendant, Eric Garay, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan and that the defendant refused to participate in the program in violation of condition number 16F.
How do you plead to that? True or not true?
True, ma'am.
Did you understand by pleading true to violation of condition number 16F, the court could find it true, grant the motion, find you guilty, sentence you to a $1,500 fine and 5 years in the prison? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, ma'am.
I believe so, Your Honor. The agreement was that you revoke his community supervision and sentence him to 3 years.
Defense, is that the agreement?
That is our agreement, Your Honor.
Mr. Gray, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
Court will follow the agreement, then grant the motion, sentence you to 3 years in prison. There's an affirmative finding of family violence. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am. I understood it.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
And also because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am. Yes, ma'am.
And everyone, just give me one moment. I want to make sure there were no contact. Yes. And also, as a part of your sentence, there's to be no contact with Barrera, Valeria, Garay.
It's a V, ma'am.
Sorry, what?
No, nothing.
Valeria?
Yes, ma'am. It's
That's
with
the name,
the
correct?
it's with the V, ma'am.
Yes.
Okay. Yes, ma'am.
All right, well, Mr. Garay, I gave you a chance to be on probation, but you would have to do treatment. You preferred to go to prison. So here's the thing, when you get out,
Yes,
you need
ma'am.
to make sure that you take care of any drug issues you have. You understand?
I will, ma'am. I promise.
All right, because otherwise you're going to be right back here. And I'm going to give you the speech that I give everybody who has a family violence case.
Yes, ma'am.
Before you get into any other relationship, you need to get an orchid. They're usually like $12. And that orchid needs to survive for a year and bloom before you consider yourself to get into another relationship, okay?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
You're welcome.
God bless you.
Oh, well, thank you. God bless you too.
Yes,
Norma, can
ma'am.
you let them know that 14A can go back?
Yes, ma'am.
All right, thank you. Thank you, Mr. Canales.
I have another case, Judge, in your court.
Is that Dominique Devine?
Angelina Macias, PSI also.
Okay, who is on the PSI front? Macias?
It'll be me again, Judge.
And are you ready?
We've got Miss Victoria. She's one of the victim's mother. She is on the screen. She'll be doing an impact statement.
Okay. All right, since she's doing a victim impact statement, do you all mind, Mr. Devine? Do you all mind if I take Mr. Devine very quickly? Jorge, I know you've been patient. Are you okay if I do Mr. Devine's case?
That's fine, Judge.
All right, who's the attorney? He's not there anymore? All right. Well, you know what? Things happen for a reason. All right, the court is calling 2020 CR 11694, State of Texas versus Angelina Macias. Can I have parties announced for the record, please, for the state?
Meredith McIntyre for the state.
For the defense?
Jorge Canales for defense.
All right, we're proceeding by video. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Ms. Macias, do you have any objections to us proceeding by video?
No, ma'am.
And the court will note for the record that the defendant's plea was entered by video as well. The defendant entered a plea of guilty to robbery and applied for deferred adjudication. The court found there is sufficient evidence of guilt. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state opposes any applications for community supervision or deferred adjudication. This will run concurrent with 2021 CR 4248W. And there's to be no contact with Jasmine Reyes. And the court then will also call 2021 CR 4248W. Any objections to us proceeding by video on that case as well? State?
No, Your Honor.
Defense?
No, Your Honor.
Ms. Macias, any objection?
No, Your Honor.
And that cause number, the defendant pled no contest to the offense of aggravated assault with a deadly weapon. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. There's an affirmative finding of deadly weapon. The state opposes the application for deferred adjudication. This will run concurrent with 2020 CR 11694. There's to be no contact with Teresa Marie Castro, Felicity Ortiz, and Gabriela Rodriguez. Have both parties had a chance to review the PSI report?
Yes, Judge.
Yes, Your Honor.
Any objections to the PSI report, State?
No, Your Honor.
Any objections, defense?
None, Your Honor.
All right, State, you're opposed. You may begin.
Your Honor, at this time, the state feels like in each one of these cases, based on the facts that you can see presented in the PSI, as well as the stipulations from the original plea agreements, that this is the type of incident where probation, any form of community supervision, is inappropriate. This particular defendant, Ms. Macias, was involved in 2 separate violent offenses, one while she was out on bond for the other. She placed 2 different individuals, both females, in fear for their life. She doesn't want to take responsibility, Judge. As you can see in the PSI, she talks about how she's not a violent person. She just has a drug problem, and that both cases were self-defense. And Your Honor, the state feels like, although she is young, and we will admit she does not have an extensive criminal history, one of the first steps for successful community supervision is to take responsibility for what you've done. We do not feel like she has done that. We feel like she's minimized what's happened in these cases, both of which victims were highly terrified, so much so that they almost didn't want to complete the process to get the crimes reported, but nonetheless did. Later on, we will have an impact statement from the mother of one of the victims who was too concerned of retaliation and didn't want to participate in the process. Your Honor, we're asking that her applications be denied in both of these cases, which do run concurrent, and we're asking for you to assess towards the high end of the cap from 5 to 8 years for these offenses.
All right, defense.
Yes, Your Honor. Ms. Macias has had and has been diagnosed for several conditions since she was a child. She had a juvenile record resulting from those conditions, I'm sure. She's been diagnosed with having ADHD, a bipolar condition, depression and anxiety have been diagnosed also. She had been on medications, but it seems like her problem is when she gets off the prescribed medications, and she does have a drug problem, and so admits. So that has led to her situation now. She has not received any extensive psychiatric treatment as an adult, which is, I believe, what is called for here, a structured type of treatment at a facility, as I believe the TAP evaluation is recommending if you are considering probation. I believe this young lady needs help, Judge. Fortunately, there wasn't any serious injury in these cases, but there were some injuries, but nothing serious. The thing is, this young lady, I feel, needs a structured treatment program that the court would propose or put as conditions if she is granted probation. And I think that a better witness would be her mother, who is present and has dealt with this with her and her conditions. And I would like to call her.
All right, what is her mother's? Oh.
Mary Fuentes.
All right, Ms. Fuentes, if you could unmute yourself, please.
Good morning, Judge. My name is Ms. Fuentes.
All right, good morning. Could you raise your right hand for me, please, Ms. Fuentes? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you could state your name for the record, please.
My name is Mary Fuentes. I'm Angelina Macias' mother.
Just one moment. The defense may have some questions for you, and the state may have questions. Defense?
Yes.
Yeah, Ms. Fuentes, we've spoken about your daughter in the past few months regarding her situation, her present situation. And you pointed out to me rather recently about her diagnoses that she's had since childhood. And I would want you to explain to the judge or review those diagnoses and problems Angelina has had as a young woman, a young girl, and now as a young woman.
Okay, well, Angelina was diagnosed with ADHD when she was younger. She was going to school, she was doing good in school, and the incident happened where she was, I guess, in middle school, and they gave her placement. Well, she was put in placement, then they gave her all these medication, they gave her all these psychiatrist help, they were giving her all this help, and she did come out and she needed help. She was taking her medication as well, but at the time I couldn't really take her because I was going to school. And I just graduated being an instructor. So Angelina was, doing psychiatrist help and everything, and we kind of she didn't have a right to go to the facility because she doesn't know how to drive yet at the moment or anything. So she started going to cosmetology school as well, and she was doing good. And somehow I just think that inpatient treatment would be good for her, and probation. She's never been on probation before. Maybe, some kind of help, like for her, so they could at least, she's saying about the drugs and all that. Maybe, I really don't know, what we could do. Maybe at least help. But prison, I don't think it would be a good idea for being in prison. I know she made mistakes, but is because she wasn't on her medication, and then she was using something else as to kind of cover or whatever, she needed to do, So I just need help from you. Prison is not the thing for her right now.
Okay, so Ms. Fuentes, what you're asking from the court is that she allow her to be on probation so she can get her treatment, and even if it's in a inpatient facility, correct?
Yes, inpatient residential treatment.
Okay, that's all I have, Judge.
All right, State.
Yes, Judge, we have a few questions. Ms. Fuentes, can you hear me okay?
Yes, ma'am.
Okay, I've got a few questions to ask. And if you don't understand, just let me know and I'll try to repeat myself. first question I have was, you said that she's never had probation before, but are you talking about just as a legal adult, or are you talking about ever?
She's never had probation ever.
Because according to the PSI report, she has had probation before as a juvenile.
No, they were gonna give her probation or put her in placement. So they ended up putting her in placement and they never gave her an opportunity for probation. So she just went straight to placement. We didn't understand what happened with that, but the judge never gave her probation, or she was never like in probation or anything. They just send her straight to the placement when she was a juvenile.
Okay. And it could just be a misunderstanding of the way that the system works, but you're not saying she's never been in trouble before, are you?
No, she's only been in trouble when she was in placement, before, and that was it. She even told me the day that this little girl was picking on her.
And you're on, I'm sorry, but let's just try to keep it at answering the questions I asked.
Okay.
And this will go a little bit smoother. I appreciate it. Thank you. Next question I have is, you're saying that you think she deserves probation in these two cases.
Yes, ma'am.
Right?
I think she needs help.
And you're aware that these two offenses are both violent offenses. You're aware of that, right?
Yes, ma'am.
And you're aware that the victims in these cases are other women? Are you aware of that?
Yes, ma'am.
In fact, one of the women, inside her car, she had her infant with her when your daughter pointed a gun at her after a road rage incident. Are you aware of that?
I was told it was self-defense. Something was going on with self-defense. I haven't spoke to my daughter or anything, but I did hear that it was self-defense, that the car kept on, I guess they were going in circles. And
so my question for you is, as a mother, if your daughter was robbed, drug out of a vehicle and hit over the head and hair pulled, eyes black with bruises.
Yes.
Are you saying that person would deserve probation as well?
No, I think it would help, because Angelina's been through that. Angelina got in a situation where somebody did that to her. They dragged her and everything.
Yes or no? Would you recommend probation for that person if they drug your daughter from a car?
Help, any kind of help if they could get it, because they can't just throw somebody in there. What if she needs, if she has some kind of problems or anything, you never know.
And one more quick, are you aware that in prison they do have a therapeutic community for people that have substance abuse problems?
Well, no, because I've never been in prison, or I don't really know about the prison system,
Okay, I don't have any other further questions, Judge.
All right, any other question, Mr. Canales?
No, Judge, I would next like to call Miss Angelina Macias.
All right, Ms. Macias, if you could unmute yourself, if you could raise your right hand. Do solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand if you state your name for the record, please.
Angelina Macias.
All right, defense.
Okay, Angelina, we're here in court and you're asking the judge for probation, to consider probation for you. And why is that?
I just really do need help. I do take responsibility for what I've done, but I wasn't always like this, and I wasn't always going through a trauma that I went through. So I want to try to get help so I can fix my drug addiction that I have going on, because it's hard as a young adult, that the stuff that I've been through, and I never got help off of it. And if you would grant me that help, I would achieve it and just go back to school that I was going to school, and just back to a successful life that I was going through, But I also do take responsibility, and I'm sorry for what I have done. And I know it wasn't a violent case, but just by doing it, I'm sorry. It looks wrong, I know, but I just wasn't on my meds, and I was going through something, and I have support, but it wasn't have support that, like, if my mom went through a trauma, she never went through that. So I'm stuck by myself, and I didn't have help for that, and I do need help, so I can get back on my life how I was. I'm only
Okay,
18.
Angelina, let me ask you questions. If the judge does grant you probation, and are you gonna get treatment where the doctors are gonna want you to be on medication? Are you gonna follow their orders as far as their medication, which seems to be a problem?
Yes, I want to change my life around so I don't have to be stuck here. And just, I would want to, like, I would want to try something new, like, to try to help me with the stuff that I go through instead of using drugs or going to prison, because prison's gonna make me not think, like, it's gonna make me feel like I'm bad and, like, I feel ugly as myself as I already am here, you know what I mean? I feel ugly.
Okay,
like, this is not-
now, your mom stated that you were attending school. What were you doing, and do you intend to continue that training?
Yes. I was doing cosmetology. I wanted to do cosmetology and have my mom's business with her. I want to continue that. I only have 6 months left to go. And if I do, um, go, I'll finish it and I'll take my meds. And out of everything else, I just really just need help with my trauma that I went through. And if she please like help me with that, I will do it and I'll do whatever just to fix myself.
Okay, there's a PSI. I would notice that there was an incident that you attempted suicide. Is that right?
Yes.
Okay, so that's part of your problems that came from your conditions that you were experiencing. Is that right?
Yes.
Okay, that's all I have, Your Honor. Pass it on.
Great, State.
I have a few questions too. Ms. Macias, in the PSI report, you tell the officer that you are not a violent person. Do you remember saying that?
Yes, ma'am.
Do you still stand by that you have no problems with violence?
No, I do have problems.
You understand, yes or no, do you understand that we are here on 2 violent offenses?
Yes, ma'am.
We're not here on a possession of a controlled substance case alone, are we?
No, ma'am.
So you would agree that you do have problems with violence?
Yes, ma'am.
Okay. And would you also agree that there are certain types of crimes that prison is just more appropriate?
Yes, ma'am.
And for most people, they would believe those would be violent crimes as compared to just possession of drugs type crimes.
Yes, ma'am.
Right? And you understand that the victims have also gone through their own trauma in these cases, correct?
Yes, ma'am.
And are you still saying that it was self-defense?
On my
Both of these cases?
No, on
So
my
let's start with the robbery first.
Ma'am, I don't remember what happened, ma'am.
Okay, so you don't remember pulling
ma'am.
her by her hair out of the car?
No, ma'am.
And hitting her?
No, ma'am.
You don't remember that this incident was actually captured on social media, which is part of the reason the case was solved?
No, ma'am.
Okay. And then on the aggravated assault, you're also saying that that is self-defense when you pointed the weapon at the woman with her children?
Well, she pointed something at me first. I know there's no evidence off of that, but I'm just doing like what it was done to me, and it was self-defense. In that case, I know y'all probably won't like go with a baseball I'm saying, but it was self-defense on that. And I know no one got hurt in that process, but still, as me went through a trauma, and like what I went through, I guess I just had a.
So I have another question too. You admit that you committed the aggravated assault while out on bond for the robbery, right?
Yes, ma'am.
And so can you understand why the state and potentially, we don't know yet, but potentially the court would feel like you're not a good candidate for probation if you can't even abide by the terms of your bond.
Well, bond is a different thing. It's with paying, and I did pay all my things. I was
But one
I
of the
finished paying.
conditions is you're not supposed to pick up new offenses as well.
Well, me
Correct.
knowing that, I really don't focus on that. I really wasn't on that. Like, I didn't know it's different. Probation is gonna help me. It's gonna have me on track, you know what I mean? And with bond, it's just something I'm paying money to. I didn't get no help off of bond or nothing. Bond is not, as to me, is probation. You know, probation, you have stuff that you need to do, like classes and stuff like that. That's like what I need, you know, and monitor. No.
And
you know,
Judge, I'm gonna object at this point. Non-responsive, and it's becoming a full-on testimony at this point, but we don't have any further questions anyway.
All right. Any other questions from the defense?
No, Your Honor. Not at this point.
All right. Are there going to be any other witness from the defense?
No other witnesses, Judge.
All right. I have a question. Ms. Macias.
Yes, ma'am.
So in the aggravated assault with a deadly weapon case, you were already on bond for robbery, correct?
Yes, ma'am.
And in that aggravated assault with a deadly weapon case, according to the stipulations, you pulled a shotgun on someone.
Yes, ma'am.
And you put it up to them and said, "I'm going to blast you."
Ma'am, I didn't put it. I know it's no, like,
Where did you point it?
Well, I just pulled it out. That was it. I didn't point it at her. She was in a different car. I was in a different car. It wasn't directly in her face. It was just so she could see. You know what I mean? I didn't point it at her. I know.
So she could see that you had a weapon and you would use that weapon? Is that what you're telling me?
Yes. Yes, ma'am.
Okay. All right. Then on the robbery case, what I've read is that there was a party and that the complainant was given a ride home, but instead of being taken home, she was beaten and items were taken from her.
Yes, ma'am.
So what items were taken from her?
I heard an iPhone was taken from her.
I mean, let's not talk about what we hear because you were there.
Okay.
So what was taken from her?
Well, an iPhone.
And what else?
That's all she had on her, ma'am.
All right. So it says here, what was taken from her was a cell phone, a necklace, and a bracelet. So she's thinking she's getting a ride home, and instead she's not taken home. The car is pulled over. She's beaten up, drug out of the car by her hair, and her cell phone, necklace, and bracelet are being taken from her. So in the aggravated assault with a deadly weapon.
Excuse me?
In the aggravated assault with a deadly weapon, were you thinking, why am I here? I'm on bond for robbery. Did that even cross your mind?
No, ma'am.
And when you pulled out the shotgun, were you thinking, I'm pulling out a shotgun? Someone could end up getting killed. Were you thinking that?
Yes, ma'am. I wasn't intending to pull it. I was just to scare her.
No, these are my questions.
To me, I wouldn't hurt, not even a fly, ma'am. I wouldn't do anything like that. You know what I mean? Like, I wouldn't hurt nobody physically.
All right. Thank you. The court will hear argument. State.
Your Honor, as the state mentioned before, we feel like these are the types of cases, like we said, we're not here on just a possession case where we're just dealing with drug addiction issues. I understand they believe that addiction plays a part in these offenses, but at the end of the day, we're here on two separate violent offenses with victims, women who are one case with her young children in the car on the ag assault. On the other case, someone who just wanted a ride home and instead was dragged out of a car and beaten by a number of people, including this defendant. She's not taking responsibility, Judge. She's saying she's not a violent person. She's saying it's all self-defense. We don't feel like someone who comes in front of this court and doesn't take responsibility is the type of person who is going to be successful on probation. We also feel like she lacks impulse control. And in that, when she does make mistakes, they tend to be violent. And so for the safety of the community as well, we don't feel like she is an appropriate candidate for probation. I understand she's young. I get that. But here we are, 2 offenses in the same year. And so we're asking that you deny her application and sentence her.
Defense?
Your Honor, Ms. Macias stated about 3 times that she does take responsibility for what she did. I'm sure the court heard that. She is remorseful about what happened. And she, unfortunately, at her age, she was, even when she was out on bond and before that, before the first incident, she was hanging around with the wrong crowd. Her peers were just not proper people to be hanging with. And I'm sure the alcohol and the drugs played a large part in this situation. She's had problems ever since she was a child. And I think having a chance, the first time chance for probation, where she could show the court that she would follow any conditions that you would place on her, where she had a more structured attempt at straightening her life out. She wants to go back to school. Her mother's very supportive, and she's going to school in the same field that her mother is an instructor now, has her own business. She has the support available, Judge. I think she just needs that direction. As the TAP evaluation recommended, the structured residential facility that she qualifies for would be a definite consideration for this court. And then upon any afterwards, she could get outpatient treatment also. So with that in mind, we're asking the court to consider the probationary period and some guidance for her. The alternative, of course, is facing time, and we'd ask the court to not give her anything over 4 years.
All right, thank you. Ms. Macias, I know for a fact that when you're on bond for a case, pretrial services will give conditions. So if someone has a drug problem, they can get drug treatment while they're on bond. If someone has mental health issues, they can get help with their mental health issues while they're on bond. A lot of people will come to the court, much like they come to their parents. They want to come after the fact instead of before the fact. Your attorney did speak to me about maybe you were running around with the wrong crowd, but I guarantee you, if those people were before me and their parents were before me, they would say they were running around with the wrong crowd. And I would ask them, well, who are the people in this wrong crowd? And they would say, Angelina Macias. Everybody in the wrong crowd is a part of the wrong crowd. So, in cause number 2021 CR 4248W, the court will find you guilty. The court will sentence you to 8 years in prison. There's an affirmative finding of deadly weapon. This is run concurrent with 2020 CR 11694. There's to be no contact with Teresa Marie Castro, Felicity Ortiz, Gabriela Rodriguez. Give you credit for any time served, and I'll ask that you be placed in the therapeutic community. And cause number 2020 CR 11694, the court will find you guilty, sentence you to 8 years in the prison. This will run concurrent with 2021 CR 4248W. There's to be no contact with Jasmine Reyes, credit for any time served in the therapeutic community. In each of these cause numbers, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you have a chance to review those documents with your attorney? Did you understand them and did you electronically sign them?
Yes, ma'am.
All right, because this was a plea bargain agreement, because I followed your plea bargain agreement, And because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And each of the cause numbers, because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Ms. Macias, I know you probably think your life is over, but so much could have went wrong that night. People could have been killed. People could have died. There are people who get beat up and dragged out of cars who end up dying because they end up hitting their head on concrete. And for young people, 8 years seems like a lot of time. And really it is a lot of time, but it's not the end of your life.
Yes, it is.
Whatever you make this out to be will be completely up to you. When you get out of prison, if you decide to continue with the way you're going, then you're going to find yourself in and out of prison, or you may find yourself charged with murder. It's completely up to you. And with that, we'll go off the record. State, do you have impact?
We do, Your Honor. It should be under the name Victoria. That's the mother of the victim. I believe they are logged on. There we go. So if y'all can unmute, you'll have your opportunity. And
here's the thing, Ms. Macias and everybody on this screen, I require that everyone treats everyone with respect. So the person who's here, Victoria, will treat you with respect, you to treat her with respect, and internalize what's being said. All right, Victoria, you may proceed.
Thank you. As I was hearing everything, I'm actually happy that justice was served for my daughter. I hear everything that the issues she has, that she has ADHD, she's bipolar. My daughter has those same issues, and that doesn't justify for the actions that Angelina has done. My daughter has not done any of these things, and we cannot say that it's because they have an issue, a mental condition, that they are not on medication, because that's exactly what my daughter goes through every day. Now my daughter is diagnosed with PTSD as well because of what Angelina has done to her. She suffers from migraines every day. My daughter now has a mass in her pituitary gland that needs surgery because of this assault that day. As I heard that these actions, that the assault was not horrible, I was furious because it was. My daughter was robbed not only from personal belongings, but 10 days before graduation, my daughter went with sunglasses to graduation because she had black eyes. She had to wear a long dress to cover her knees that were scarred. Her whole body was bruised. She didn't even want to go to graduation, but I forced her because I told her this is a once in a lifetime opportunity. Everything that my daughter went through, our family has suffered, not only her. Now she even lost her job because she cannot be around people. She doesn't go anywhere by herself. And now every time right now that I'm hearing everything, it bothers me because I'm a single mother of 4 children, and it doesn't justify that they have issues. We seek medical attention. We seek psychiatric help for them. We guide them in the right direction. And that's what I've done to my children. And it bothers me because my daughter was the person that trusted everyone. And now I have taught my daughter to have to look over her shoulder. And that's not the type of person she was. That's why she was trustworthy. And it was 5 people who beat her. If she hadn't started screaming, I believe my daughter would have been dead. It's because she started screaming that they ran, and that video being shared on social media shows it. I saw that video and I was in tears. I still have that video and I never touch it. Seeing my daughter beaten and me as a mother not being able to protect her. That's what us parents do. And I wasn't able to protect my daughter at that moment. That's why right now I thank everyone right now for justice being served. And as I heard that there was another case while she was on bond, it infuriates me even more because at the time that we were waiting for this, someone else had to suffer as well, like my daughter. And that's the reason I pursued all this. I thought about it, should I? And I said, no, I need to, because people have consequences for our actions. And that's exactly what was done, and good thing. So she won't do this again to someone else. And it's very hard to hear that she did it. And that's what I was in fear of. And my daughter's here, but she does not want to come out on video. I'm not too sure if anybody can block it or blur it. but she is here and she just wants to say a short statement of how this has caused her problems.
Well, it depends on if there's going to be any objections from the defense or the state with her not showing her video. Because if we were in a courtroom,
do you mind?
You have to show her video.
Do you mind?
Yes.
Do you want mine, Jasmine?
Yes, Mr. Canales?
I would object to that non-video.
Can she wear her face mask and just show her her
Well,
nose up?
I'm sorry, but the defense counsel is asking that if she's going to be on video, that she shows her full face on video, otherwise not.
Judge, if she were in the courtroom, she'd be wearing a face mask. So I don't know if Your Honor wants to take that into consideration.
Not everybody's wearing a face mask.
Defense.
Judge, in the court, it's supposed to be an open courtroom, Judge. That's why we're on YouTube.
Okay, all right. I'm sorry, Ms. Victoria. She'll need to show her face.
You want to show her? Okay. She wrote down what she's gonna say.
Okay.
I can show my full face. Right here, just part of it, and then you just want to show your face.
Oh, you can start speaking now.
Let's see. I can see it. Why not? I'll hold it and just look at your thing, and I'll hold the phone.
You can start speaking now. We are able to see you.
What did you say?
I feel like that day made me so depressed because I couldn't sleep for weeks. Now I do have PTSD. It has changed me from that day on because I feel like I'm not the same person anymore. And I do have a lot of social anxiety now. Yeah.
She says she's done. Thank you for your time, Your Honor.
Judge, that's all we have for victim impact.
You're very welcome. Thank you for coming in. And Normie, can you let them know that L22 can go back, please?
Yes, ma'am.
Mr. Canales, thank you so much for your patience.
Thank you, Your Honor. May I be excused?
Yes.
Thank you.
And is Mr. May in the courtroom?
Yes, Your Honor.
All right, if you can come forward, please. And your client is Mr. Devine.
That is correct, Your Honor.
And Meredith, are you handling this case as well?
Yes, Judge.
All right, Mr. Devine, can you unmute for me, please? Just press the longest key down. Thank you. Court is calling 2021 CR 7370 W, State of Texas versus Dominique Devine. Can I have parties announced for the record, please, for the state?
Meredith McIntyre for the state.
For the defense?
Charles Mace for the defense, Your Honor.
We're proceeding by video. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Yeah, they talking to me.
Okay. Mr. Devine, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Devine, I'm going to show you what's entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Did you understand that you have a right to have, I'm sorry, is there Kleenex on your end or no Kleenex? Do you need some Kleenex?
No, ma'am, I'm gonna be okay.
All right. Did you understand that you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand that your attorney has certain rights, namely 2 days from the presentation of information and 10 days from the presentation of the information prepared for trial?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Next, I'm showing you information. Did you review that document with your attorney? Did you understand it?
Yes, ma'am. Yes, I did.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Judge.
And are you going on this as an unauthorized use?
No, Your Honor, we're going on it as a theft, but the state jail punishment range. So it was originally the third degree, but we're doing the 2,500 to 30,000.
All right. Did you understand what you're charged with then is theft of a vehicle, $2,500 to $30,000. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility. Did you understand?
Yes, ma'am.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am. So I wouldn't waste any of the state's time.
All right. Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Devine, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is requesting that you be sentenced to 180 days in the state jail facility. Take in consideration NIMAG number 599494, County Court Cause number 649504. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm going to show you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None, Your Honor.
Then to the offense as charged in the information, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
State offers State's Exhibit 1 and all attachments.
Any objections?
No objections, Your Honor.
Mr. Devine, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Yes, ma'am. Was I supposed to answer? I'm sorry.
No, just give me a moment.
I'm sorry. Well,
all right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes.
Are we proceeding with sentencing, Mr. May?
Yes, Your Honor.
Court will follow your plea bargain agreement, sentence you to 180 days in the state jail facility, taking consideration night mag number 599494, county court cause number 649504. Give you credit for any time served. I read in the police report that they both had parole warrants. Is that parole still active?
It is. It's like it was like it's just short. I mean, it's a non-violent.
Does anybody want this to run concurrent with parole?
Yes, Your Honor, we would ask that one.
We don't object, Judge.
Does anybody know what cause number that is?
No,
I
Your
don't
Honor.
have that in front of me, Judge. I know it's out of state, but I don't have the number in front of me.
All right, because I don't know if in the police report, it says OCA 148-124 and 142-63300, but both of them had parole warrants. So I don't know if, I'll just say concurrent with parole. Yes.
My parole in Arkansas was my initial sentencing was commercial burglary.
No, I just need the number.
I'm sorry, I can't call out this CR court docket number. Sorry.
No problem. I believe he's OCA 14812, but I'll put the other one in here just to be on the safe side so that it'll run concurrent. Whether or not they place this concurrently or not depends on parole. If you had already been violated on your parole, then it will run concurrently for sure. But I don't have any jurisdiction over your over your federal matter to make a determination of whether or not they'll run it concurrent.
I'm currently just well, before this charge came up, I was waiting on, if it wasn't for this charge, like I was waiting to see if Arkansas would come and get me because of the pandemic.
Okay, all right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, with that, we'll close the record. Mr. Devine, you need to start doing better. Otherwise, you're going to find yourself in and out of prison, either in and out of a state prison or in and out of federal prison. Do you understand?
Yes, ma'am.
All right, good luck to you. Norma, you can let them know that 14B can go back.
Yes, ma'am.
All right, thank you, Mr. May.
Thank you, Your Honor. May I be excused?
Yes.
Thank you.
And everyone, I've kept us here later than anticipated because I think we only have 2 more cases left and we will be done for the day. Norma, do you know why Mr. Ferguson is with us?
Judge, hold on, Judge.
Judge, that's my case. I messaged Norma earlier. I filed a writ of habeas corpus for my client. I don't have an agreement with the state. If you have time, Judge, I would just ask for a few questions from my client and brief argument.
Yes. Okay, I'll take your case up. You've been very patient waiting for us. I appreciate that.
Thank you, Judge.
And then after this, everyone, we're going to take a break, but we're not going to be coming back at 2. We're going to come back at 2:30. And my understanding, what we have left is, actually, I don't think we have anything left. Norma, I do have a Clayton Marr.
Okay.
I don't know why I have that file. It's 2021 CR 3427. All right, who's the prosecutor who's going to be handling this case?
It's me, Judge.
All right, I don't see, it just did this crazy thing again, Brenna. See, it does it again. I don't know what's going on. Yeah, all right, well, we won't be doing that because it's not behaving appropriately. All right, court is calling 2021 CR 4559, State of Texas versus Rodney Earl Ferguson. Could I have parties announced for the record, please, for the state?
David Martin.
For the defense?
Christine McDonald.
We're proceeding by video. Any objection from the state?
No objection.
Any objections from the defense?
No, Your Honor.
Mr. Ferguson, could you unmute yourself, please?
Yes.
Yes. Do you have any objection with us proceeding by video?
No, ma'am.
All right, state, have you had a chance to review the defense's motion for application for writ of habeas corpus and motion to a reasonable bond? Have you had a chance to review that?
Yes.
Are you ready to proceed?
Yes.
All right, defense, is your motion?
Thank you, Judge. Can I just take a brief testimony from my client?
Yes. Mr. Ferguson, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, defense.
Thank you, Judge. Mr. Ferguson, can you please tell this court how long you've lived in Bexar County?
Over 19 years,
And how long have you been incarcerated?
5 months so far.
And we had a bond reduction hearing back in April. Since that time, have you been able to reach out to anyone about the bond?
No, ma'am,
Why not?
because I have nobody here. It's just me.
You don't have any friends or family members that you can reach out to?
No. No.
Before you were incarcerated, were you employed?
Yes.
Where were you employed?
Illusion,
How long were you working there?
like 4 years.
Have you consistently been employed since you've worked here in since you've lived here in Bexar County?
Yes, so I've been, yeah.
Where were you living before you were incarcerated?
IH-35 2018. Cost, I'm selling those apartments.
Okay. And is that the address of the complaining witness?
Yes, ma'am.
And since that time, and if you were to post your bond, where do you have an address where you can go?
The Haven Park, that's one place I can go.
So you'd be planning to live on the Haven campus.
Yeah.
Have you ever been, let me see. What about transportation, Mr. Ferguson? Would you be able to get to and from court settings and pretrial bond hearings if necessary?
Yes, ma'am. Via or walk, like I usually do.
Is that what you're used to using as far as transportation?
Yes.
Okay, and you were still able to consistently hold a job even though you relied on the bus. Okay, and Mr. Ferguson, do you have any requests or anything you'd like to ask the court when considering whether or not to reduce your bond today?
No, ma'am.
Okay, Judge, I have no further questions.
State?
I have no questions.
All right, then the court will hear argument. Defense?
Thank you, Judge. Your Honor, I filed this bond reduction hearing in response to jury's trials being suspended again, Your Honor. My client is indigent. He has no friends or family to reach out to make a bond, Judge. So I understand that $10,000 may seem like a low bond, but to my client, Judge, where it is right now, it might as well be no bond. He has no one to reach out for. I ordinarily don't comment, Judge, on the nature and circumstances of cases in bond hearings, but I have drawn the state's attention to the facts of this case multiple times. The officer actually comments on the body cam that the victim's wounds look self-inflicted, Judge. We are going to assert our trial right, and I have no idea how long until my client will get a trial, Judge. And as the bond is right now, there's no way that he can afford that, Judge. We did get a reduction in April, which the state agreed to. Since that time, he still has not been able to post that bond. As far as the future safety of the victim in the community, Judge, A defendant who can make bail is not less of a threat than one who cannot, judge. With a GPS monitor, this court can assure that my client will not come in contact with the complaining witness. And there's just no other there's no other crimes in his history, judge, that would indicate that my client is a danger to the community. So considering all that, I'm asking you to set this bond at $2,500, judge. Thank you.
All right, State.
Judge, we did already agree to a reduction to $10,000, and he's currently indicted for a violent offense, and he's indicted as a habitual offender for 2 violent offenses. I think that would show that he is a danger to the community. I think the $10,000 is more than a generously low amount for this type of crime and a habitual offender, so we would just object to any reduction at this time.
All right, defense, it's your motion, so I'll allow your final argument.
Just briefly, Your Honor, and as I indicated from the facts before, this is an aggravated assault with a deadly weapon, but there is multiple indications in the evidence that's been available to the state that the complaining witness is completely inconsistent. Another thing, Your Honor, although he does have, he has been convicted of an assault family violence case before, that case was from 2008, judge, and that's all I wanted to bring to the court's attention.
Okay. All right, the court is going to deny the motion. Is there anything else from either side?
Not from this one.
None from the defense, Your Honor.
All right, thank you. With that, we'll close the record. Do you need to speak with your client anymore?
Just if I will, just Mr. Ferguson, I'm going to set a jail visit with you tomorrow. Okay.
Okay.
All right. If you wanted to speak with him now, you can. It's just completely up to you.
Okay. Yes, briefly, Judge, if that's okay. Thank you.
Yes. All right, Mr. Ferguson, I'm going to send you to breakout room. Let me find you. I'm going to send you to breakout room number 1.
Okay.
And everybody, I'm going to stop the live stream. So, and see everybody tomorrow. I believe tomorrow we're going to start in the afternoon instead of the morning. Norma, what time are we starting tomorrow?
1:30, Judge.
Yes, so we're going to start